2012, no, I'm sorry, 1CA CV 20-0104. I'm a little too used to that Superior Court code still, I guess. It is Nolan Real Estate versus the Hartford Steam Boiler Insurance Company. I know I short named both of those, but I think we know who we're here for. We are videotaping this. It will be streamed later, but it is not live streamed because of our virtual presentation. We are, as we go through this, keeping track of time. I have a timer that I use. What I will do is ask that you folks also keep track of your own time. We are not responsible for keeping track of that for you, though I will be keeping track of your time, and we'll try and give you signposts along the way. Feel free to ask me where you stand as far as your argument, if you have any questions for that. You're welcome to reserve any time you want for rebuttal. That is something you reserve on your own. And so just keep an eye on your own clock. And again, I will give you those signposts. We know that this is a little awkward, so please keep an eye on the screen to see if the judge is trying to ask a question, and hopefully you'll be able to see and hear us and make that work. We did, and keep in mind, conference this case earlier today and discussed it extensively. We have read all the briefing, we have reviewed the record, so we are very familiar with the case, and so each of you have 20 minutes, and I'll allow you folks to begin now.
Thank you, Your Honor. Good morning. Cameron Artigue for the appellants. Let me know if you can't hear me or there's some other issue. In this appeal, as in all of them, the critical first task is to identify precisely the nature of the error that occurred. And the key point here is that the error did not consist of the fact-finding function. The jury was not wearing a fact-finding hat when it made an error here. The jury was interpreting the insurance policy. So remember that when this case goes to trial, it's going to the jury as a clear and unambiguous insurance policy. So there's no fact question regarding the meaning of the policy.
Counsel, this is Judge Weinstein. Let's break that down. The jury received a jury instruction that defined terms in the contract. Is that correct?
Yes, it is, Your Honor.
Okay. And who defined those terms?
Well, the instructions were paraphrases of the policy terms. You know, they came obviously from the trial court judge, and they were agreed upon among counsel.
Who defined those terms? Did the court define those terms?
Well, Your Honor, I think that the terms obviously are rooted in the policy.
Well, obviously, we have a contract. We have an insurance contract. And I have jury instructions that provide definitions. I'm asking who made the decision to define those terms?
The carrier.
I have a follow-up question.
The carrier wrote the policy, Your Honor.
So is the term mechanical breakdown defined in the policy?
Well, yes, Your Honor. I mean, it's defined as excluding wear and tear, however caused, and excluding any gradually developing condition. And there's no jury instruction issue here. I mean, I will agree that the carrier wrote the policy and that the instructions track the policy.
Yeah. Okay. Well, counsel, I have here the jury instructions in front of me, and we have the terms mechanical breakdown. We have definitions here where a mechanical breakdown and fortuitous event that are undefined in the policy, but are defined in a jury instruction. And I'm not trying to, slip something by you. I'm just asking. I think is that a legal question, interpreting a contract? And who came up? Because these words are not, if that's what you're saying, defined. I don't believe you can point me to the record where those terms are defined: fortuitous event and mechanical breakdown. They are, though, defined in the jury instruction. And so my question to you is, who interpreted those undefined words that are otherwise in the insurance contract?
Your Honor, I was not trial counsel. The jury instructions were crafted, as you would expect, among trial counsel and the court. There is no objection to the instructions that were given. This whole appeal arises under a different section of Rule 59.
Yeah, no,
this is not a jury instruction appeal.
Let's follow up with that. So you did not, and you in fact do not contest those jury instructions.
Correct.
Okay, and so the jury here received an interpretation, a legal interpretation of words in a jury instruction, and applied them to the facts. Where do you win here? I mean,
Your Honor, the no jury instruction can turn a question of law into a question of fact. And
are you telling me this is some pure question of law, and there's no notion of going outside the four corners of a document? And that's not the law.
Well, I guess I would tell you this, that the facts here, per the plaintiff, were that this part failed over time due to wear and tear. Now, try as you might, no jury instruction in the world can enable a jury to look at wear and tear and say, gosh, that's not wear and tear. Under a clear and unambiguous insurance policy, I guess.
Well, let's jump in that. Let's follow that. Okay, so you're okay. Now we're moving to substantial evidence based upon uncontested jury instructions, and I think what you're saying is there's no evidence in the record to support what was a legal interpretation of the words wear and tear as conceded by your client. Is that correct?
No, Your Honor, you're trying to put me in a fact-finding box. I am not arguing that this verdict is against the weight of the evidence. I'm arguing that it's contrary to law under Rule 59A1H. If a jury looks at a bicycle accident and finds coverage under a motor vehicle policy, that's a legal error. No jury instruction can bless that.
Okay. So you're saying contract interpretation is always a legal question, and it doesn't it doesn't raise factual issues, whether it be in a parole evidence context or elsewhere.
Well, yes.
And still, even there, the court. I mean, you're saying you wanted to make the decision and interpret terms. Seems to have done that with the help of your client.
No, I don't think I agree with what you said, Your Honor, but I don't think a court has fully discharged its role as the arbiter of the law by giving jury instructions. If you give instructions and the jury comes back with a verdict, I mean, a Rule 59 motion cannot be ripe until the verdict is returned. And the rule provides for setting aside a verdict that is, quote unquote, contrary to law. So if a jury comes back, even if properly instructed,
okay. So let's go. How is this contrary to law? What precisely is that? Maybe we'll go down that rabbit hole and see where that leads us. What I'm going to want to know, and I'm going to want to point out, is in this trial you have Nolan's expert categorically excluding wear and tear. You have, and again, this is, we're an appellate court. We're not. This isn't. We're not fact finders, but you have a manufacturer of this very part that changes the rubber material used because it is breaking down. Okay, you might say that's wear and tear. What if there's some inherent flaw in the chemical in the rubber, and that's what the jury concluded? That's not wear and tear.
Okay. Couple of responses to that, Your Honor. Nolan's expert did not categorically exclude wear and tear. What he said was, we believe Carrier was correct. What Carrier said, and this is at page 19 of the appendix, Carrier said that the seals were badly worn. I'm quoting here. This occurred over time, and that as the rubber wears, the springs begin to score and scratch. This ain't me. This isn't my witness. This is the plaintiff's expert. That was their case. So you have as a fact that this wore out over time. At that point, the fact-finding function is complete. And if the jury comes back and says, well, we return a plaintiff's verdict, again,
let's say it wore out over. I'm sorry. Go ahead.
No. That's and you mentioned, well, it could have been a manufacturing defect.
Let's go back. Let's say it wore out over time, and it turns out, I'm not a chemistry person, but there was some essential chemical that was missing in this, and what might look to most people as wear and tear actually was impacted by, and who knows what percentage, it's hypothetical, but by some amount on the rubber, the chemicals used for that rubber. That hypothetical would also.
So let me jump in before you answer. Go ahead, finish your question.
Oh, is that wear and tear as well? If there was a chemical defect in the rubber that was causing it to erode?
No,
because you're at 9 minutes and 30 seconds. That's what I wanted to do.
Okay, Judge Weinsweig, what the policy provides, the clear and unambiguous policy, is that wear and tear is not covered, however caused. So the rabbit hole of maybe this was a design defect, maybe this was the explanation, maybe this was the explanation, is irrelevant. It may be a fact issue, but it's not a material fact issue because it doesn't matter. So Judge Gast, did you have a question, or should I?
I was making sure you heard your time, and then I will ask a follow-up question, because you pointed out that it was, the movement, the rubber wearing out, but then you said something which allowed the springs to scratch.
Yes.
Now, isn't it within the jury's prerogative to find that those scratches were not in fact wear and tear? And as a result, those scratches alone would support the jury verdict, because remember, we're looking for any fact that will support the jury verdict.
Yeah, Your Honor, I think that saying, oh, it's not wear and tear, it's scratches, you have departed from the common understanding of the word wear and tear. If you'll remember the show Family Feud, if you ask people, name an instance of wear and tear, scratches is going to be on every list. And you can't say, well, that's not wear and tear on the tire. That is degradation of the rubber on the tire. And as we say in the brief, if you say, well, it's not wear and tear, it's scratches, you have reduced the policy provision to a nullity.
Well, not so. Let me ask you this. Because the part that failed from wear and tear was the rubber piece. That failed. As a result of that failure from wear and tear, other things happened. The springs scratching were not a wear and tear. That was not something that would normally happen if everything functioned properly. It is a subsequent event, much like the gasoline stays in the tank, The tank wears out and it leaks and there's an explosion. Well, what happens with that exploding gasoline is a covered event, much like what happens, or the jury could find, is what I'm trying to determine, that what happened with those springs after the wear and tear was a covered event.
Yeah, I mean, you're right, Your Honor. If there's an explosion, yes, you get to a covered event. What Carrier said, and this is what plaintiff agreed with, is that the springs, the scratching and scoring on the springs is part and parcel of the failure of the rubber. Just like when a tire wears out, eventually you get down to the rim, and that is wear and tear.
Could we be careful? Somebody seems to have unmuted, so we're getting some feedback. If everyone besides counsel could make sure they're muted. Thanks.
Judge, if I may just check my time, I think I have about 5 minutes left. Do you have the same clock?
I have 5 minutes and 45 seconds.
Okay. I guess I would just, I want to reserve some time, but I would leave the panel with this idea that, we cite cases in the reply brief on pages 4 and 5 where courts will reverse verdicts when juries have returned verdicts that create insurance coverage that is not provided in the policy. So there's a role for an appellate court here. And I would submit, given that the plaintiff says we go with what Carrier said, which is that this part wore out gradually, this is tantamount to, a verdict recognizing coverage for a bicycle accident under a motor vehicle policy. It's an error of law, and that's my hook into Rule 59. With that, I'd like to reserve the remainder of my time.
I'm going to ask a follow-up question, so I'm going to take a little of your remainder, which is this. When one thing wears out, and I'll use a pipe and a wall, the pipe isn't covered, but all the damage that flows from the water that flew out of it and damaged the rest of the house, that's a covered event. Isn't this the same thing? The little rubber piece isn't covered, that wore out, but it released the spring that caused other damage. The spring, like the water, wouldn't that be covered?
Well, no, Your Honor. I guess, a scratch on a spring is itself, I'm just appealing to the common understanding of what a scratch is. As I said in the reply brief, all of us deal with scratches on our phones and our furniture every day. And I think that scratches and abrasions are commonly understood as wear and tear, just like thinning carpet. Thank you.
Thank you. Do you have about 3 minutes and 40 seconds? Counsel, give me just a moment to reset. All right, whenever you're ready, Mr. Larson.
Thank you, Your Honor. Well, actually, with your questions, you've actually focused in on what I believe to be the fundamental error in the approach taken by HSB on this appeal, which is just because they say that the issue is it was against the law, we don't look at it through our standard rubric of here we are on appeal, and therefore we have a jury verdict, and now we look at it for is there evidence to support the jury verdict. There's nothing that changes about that just because they want to look at it as against the law.
So counsel, let me ask you a question. So we have this notion that interpreting a contract or an insurance contract here was an exercise in law, and we're dealing with I think the argument would have to be a provision that is so clear and unambiguous on its face that you don't even have to go to the second question. Is that how you how you understand the law as far as whether or not something is just strictly a legal question for the court, or might be more nuanced?
Sure. Judge, every single case that goes to trial has mixed questions of law and fact. Every single contract that goes to trial has mixed questions of law and fact. And we all know that what's over on this side, we have the judge who has to decide what the law is. And then we've got the jury that's going to decide the facts. And where the rubber meets the road then is you tell the jury what the law is and how the law is going to impact their view of the facts. And that's exactly what happened here. The question earlier was, where did a couple of these definitions come from? Well, during the trial of the case, for example, the people, the witnesses for HSB would not tell me what the definition of mechanical breakdown was, for example. So both HSB and we offered to the court our suggestions. Judge Mraz took a look at it and we worked back and forth and came up with definitions for the undefined terms because we thought that would help the jury. And as noted, there's no objection to them. So once we've got
let me stop you there. So this is in Taylor State Farm, the Supreme Court case of '93. It says that when a contract is reasonably susceptible to more than one interpretation, that's a quote, the parties may introduce external evidence to help interpret the contract, and interpretation, quote, thus becomes a question for the jury, end quote. Is that what happened here? What was the point that this clause, and I guess if it's wear and tear, is reasonably susceptible? I'm not saying it means one thing or the other, but there's an argument, and that is when it became at least a question for the jury.
Well, I think it was a question for the jury before that, Your Honor. But it is true that we brought before the jury issues related to how HSB reads this policy. And for example, we had to, it took us like 4 years to get other claims from them, examples of other claims. But when we got them, and we cite them on in our brief, there are two of them. But so HSB itself, in terms of how it interpreted this policy, and we gave our two best examples, but one of which was the second one. And well, it sounds like you're very familiar with our brief, so I won't stretch for looking for that particular location for it. But the point is, HSB has paid for claims which are exactly what Judge Goss described, which is where there was a scratching. In fact, a bearing wore out, and the bearing wore out over time, but then it started scratching other parts, and that was called a covered event in another HSB claim.
So your point there is that, this was reasonably, again, that's the language, susceptible to more than one interpretation. In fact, look at HSB's conduct. They have in the past so interpreted. So that's another data point or evidentiary piece to show that this isn't a self-defining term like the sun or earth. I mean, that's more evidence to show that there was a dispute as to the meaning. Is that what you're saying?
Absolutely, Your Honor. And yet another data point for that is we asked, and I quote this on page 25 of our brief, but we asked their senior vice president of claims who was at the trial. We asked him, let me ask, it's on page 25, let's ask, what if wear and tear causes an accident? Is that covered? His answer was, there are scenarios where wear may lead up to an accident. Yes, that would be covered. So yet another example of the same issue. And the jury heard all of this, and which fits into the rubric that we're speaking about here, which is there are mixed facts, and you've hit it on the head, Your Honor. When there is a potential way to interpret this differently, it becomes a mixed question of law and fact. As long as we instructed our jury correctly, and Judge Mraz, after 7 days of trial, worked very hard to try a good case, and I think she did. I didn't get all the rulings I wanted, but so that happens frequently. Bottom line is, we should give the jury, I believe, it's accorded its give it the credit it's due, and as long as there's something to support it, substantial, reasonable evidence to support it, we should go with it.
Let me ask you, at summary judgment here, the question was presented to Judge Mraz that we have a contract with these words, and they should be interpreted, as follow. There's no question of fact. Did she articulate anything at that point in time as to number one, what fact questions remained, or two? Well, let's start with that.
So the answer is a little bit nuanced. It was Judge Ray who heard the summary judgment, which was a while back, and Judge Ray said his response was to their summary judgment motion was they haven't, that our focus is not on a wear and tear claim. It's on something that is clearly different than that. I've got it somewhere, but anyway, that was his. But the issue to be tried, left to be tried, was, in fact, Judge Ray during oral argument had asked me, why didn't you file a counter motion for summary judgment, Mr. Larson? And my response was, because there are questions of fact here. I have to prove that there was a mechanical breakdown, and in this case, and if this was a mechanical breakdown, then we have coverage. Their claim is it was only wear and tear, and that was the only thing going on here, and that's the issue that had to get tried to the jury. I hope that I covered what you were looking for there.
Yeah, I was just trying to get a better handle on summary judgment here, but I can also go back.
Well, I don't mean to put you through that, if I can avoid it.
It just seems like your colleague, not Mr. Artigue, but your colleague at trial would have raised this purely legal issue and for the court to dispose of. And the court either said, yeah, I can, or I can't. But you say you don't remember if there's like a written order or a minute entry explaining what facts might preclude summary judgment?
Your Honor, I don't recall the specifics of it other than.
Okay. That's fine. Keep going.
It was the April 2014 order by Judge Ray, if you're looking for it. And I've got some of the information if I dig a little bit for it. But
keep going. Sorry about it.
No worries. Okay, so
while you're doing that, counsel, before you start, you're at 9.5 minutes. I just want to give you a little road time.
Thank you, Your Honor. Appreciate it. So opposing counsel, I'm sorry, HSB in this case, Mr. Artigue, if we look at their, they say there are, we've cited a couple of cases, they cite a couple of cases where it's true, as a rule of law, if there is no dispute on the facts and the jury makes a wrong turn, well, then of course, this court should deal with it. The two ones they cite were, for example, the cotton was too close to the cotton gin. Well, everybody knew exactly how far cotton was from the cotton gin. And so it was not a covered event. Another one was they cite a case where they were only permitted to use certain pilots. Well, or certified pilots, and the pilot that flew the plane and wrecked it was not and so those cases go up on appeal, and there is a very specific fact that is very clear to everybody. And when you have that, yes, it's this. I think it's an old case. It's the Queen's insurance case that was cited, and I can't even remember who cited it at this point, but it's the same issue that you described earlier, Judge Weinswig, which is construction of fire policy in this case. If the facts are, it's a question of law if the facts are undisputed. But if fact question, it's for jury if disputed. But I'm sorry, fact questions, and that's what we had. We had numerous facts in this case. If you were to tell the jury that these were undisputed, that there were no disputes on the facts of this case, that they listened to, I think they'd be pretty surprised. I think, as would Judge Mraz, that we were certainly presenting different views of what happened out there over the course of the 7 days.
Well, but you would agree all facts aren't created equal in this context.
Sure.
We would need facts that go to that. What was the language used in State Farm? The reasonably susceptible interpretation, right?
Mm-hmm.
Not.
Sure. There were facts related to the reasonable susceptible interpretation, as well as facts related to what precisely happened out there on the property. Very true, Your Honor. And again, it sounds like a broken record, but you know, we really tried to put this all together in a carefully crafted, so the jury could, every single policy term is in that jury instruction, that they needed to look at. And then when we thought they needed something that needed to be defined, we worked hard to come up with a mutually agreeable, or at least the court ended up ruling on it, definition, and they didn't object to it. And we didn't either, is what ended up happening with the jury. So I think that's...
Could you clarify something for me?
Certainly.
And that is, what exactly is the property damage, whatever you want to call it, that was not wear and tear that the jury could rely on?
Absolutely. So what happened, and it's actually, Judge Goss, what you described earlier. Once the seals wore out, and I agree that the likelihood is that there was a manufacturing defect. And there are other reasons that could have happened, but their expert's the one who found out that they had to replace this particular spring. But anyway, once that failed, it's all these scratchings that are happening to the shaft and the piston of the property, and they are damaging it. And everybody, even their expert, agreed that that was not expected wear and tear during the life of a counsel's point that scratches are wear and tear. If somebody scratches my car, I can tell you, I don't think that's wear and tear. I think that's damage. And I think it's not, yes, scratches happen, but, and they could have, if they wanted to, said scratching in their policy, I guess. I can't imagine that they would have, but I don't perceive that as, I don't perceive that as, even their expert referred to the scratches as damage. And one of the other claims that we cite, which are, one of the claims that we cite, the first of the two that we cite in our brief, that are other claims of theirs, talk about damage caused by a spring. And they've specifically referred to it once again as damage. So I think that as I view it, there's not much question. Certainly wasn't ever a question in my mind, but it doesn't really matter what I think. What could the jury reasonably infer from that? And the answer is it was damage caused by a functional defect in another part.
let's think of it this way. If there had not been this failure of the rubber piece, but there were scratches on the inside of this from the piston moving back and forth as it's designed to do, would that be the difference in a scratch that's a wear and tear versus a spring that has gotten out of its, I forget what you called it, the rubber piece? Does that make sense? In other words, we expect this piston going back and forth is going to create etching or something. We know that's always going to happen. But it's different when it's the spring that causes it, because, and I don't think there's evidence, so that we're being clear, I'm asking hypothetical. Hypothetically, that we know this piston's going to do that. And so over time, we know something's going to need to be replaced because this piston's always going to do it. But there's a spring that we expect to stay in its little sheath, not pop out and not scratch. And then that sheath wears out and the spring does it. Is that like two different fact situations? One where there would not be coverage, the piston doing it as expected, coverage where the unexpected happens, the wear and tear is not really something that happens, but that spring causing the scratch is not expected.
Your Honor, I would agree with you that if in that situation, it is more likely I would reach the conclusion. I'd want to maybe look at some other factors, but on your pure, hey, this is something that just simply happens. Everything's still in its place. Everything's functioning like it's supposed to. That's exactly why wear and tear got, its expected contacts with other things over the course of its natural life. And if that's all we're talking about, then that's wear and tear, and we agree it's not covered. But once it's not that anymore, once there are, it's something else, it's damaged something else, then that's a completely different scenario, that we're damaging other things. I hope that addressed your...
I think it does, and you're at a minute, so you know.
Okay. I want to briefly address, boy, I hate coming off of this one, but I do want to briefly address this issue of the valuation clause. And I'm just going to hit a couple of highlights with it. The valuation clause, this is their point 2, is designed for one thing in particular, and that is it is to address the situation where somebody gets 2 bids for fixing, for example, their car, and they fix it for the cheaper bid, but they want the insurance company to pay the higher bid. That isn't how that is worked. And let's just give you a quick example. I wreck my car and I decide not to get it fixed, or I can't afford to get it fixed. In that scenario, according to what they're saying, they don't have to pay anything because I have spent 0. The fact is the damage was not 0. The damage was something, and we cover other aspects of that in the briefs. I hate to get us completely off topic, but I did want to address that briefly.
All right, and so you're at your time then, counsel.
I probably have. Thank you, Your Honor.
I try and stop this. Counsel, I need to get you back to your time, so give me a moment to reset. All right. So, Mr. Artie.
Thank you, Judge. On the scratches question, I would respectfully direct the court back to what Carrier said, which is what the plaintiff said was their position. Carrier said that the scratches occurred over time and that it was a gradual thing. So I'm sure, Judge, you can hypothesize a failure that causes a sudden explosion, and it is agreed that that would be an accident. But remember here that the policy excludes wear and tear and any gradually developing condition. And when a plaintiff says, hey, our position is that this happened over time, they have removed themselves from the scope of that policy. So I'm very wary of asking you to sort of delve into the facts because you're an appellate court. But that's what the facts are. Judge Weinswag, you tried to reframe this as a reasonably susceptible to two interpretations situation. Judge Meraz said in her minute entry of May 28th that the policy is clear and unambiguous, and it was never tried or framed or resolved as an ambiguous policy kind of case. There was no evidence of what the agent said or what somebody believed. This was a matter of law, straight interpretation of an unambiguous insurance policy situation.
Well, just because you say it's unambiguous doesn't make it unambiguous, right? I mean, I don't understand. You're saying because that wasn't raised specifically, that this was reasonably susceptible to another interpretation, then there can't be a fact question for the jury.
Well, yeah. I mean, it wasn't any party. The court said that it was clear and unambiguous, and no party on appeal has quarreled with that. Now, that raises the question, which Your Honor dealt with opposing counsel, what exactly was the fact question that the jury supposedly resolved here? And I read the appellee's brief carefully with that question in mind. And if you read it, it turns out that the quote unquote fact question is whether there was coverage under the policy. Was this wear and tear or a gradually developing condition? And respectfully, that is not a fact question. In this respect, I think the insurance policy is analogous to a statute, and interpreting a statute is a job for the court. And you can, in a jury instruction, you can quote the statute, you can paraphrase the statute, you do your best to instruct the jury. But if the jury comes back with a verdict that is contrary to the statute, you got to fix it.
But is it completely out of the realm? Is it completely out of the realm that the jury, listening to the undisputed meaning of the this particular contract provision, found that the scratches were not sufficiently done over time to constitute wear and tear? That's an issue for them, isn't it? In other words, you can tell me that those are the facts that the jury gets to figure out. Does it fit the contract?
Yeah, I think it's an issue for the jury if there's any dispute about that. But when it is undisputed that the scratches occurred over time, I don't think the jury's got a role then. I mean, like I keep coming back to the motor vehicle example. If it's undisputed that we're talking about a bicycle, there's no way for a jury to say, hey, there's coverage under a motor vehicle policy. It just doesn't, that's where the error of law occurs.
Well, but I thought you agreed earlier, though, that if there was some sort of chemical imbalance in the rubber that caused it to erode over time, that is not wear and tear.
No.
Finish this answer, but then you're at your time, counsel.
Yeah, I'm sorry, Your Honor, if I was ambiguous. No, the wear and tear and gradual condition exclusions are both contain language that they're excluded however caused. So what I tried to say earlier, okay, Judge, is that it doesn't matter.
I see what you're saying.
All right, thank you, counsel.
Thank you.
We appreciate your arguments here today. We're going to take this matter under advisement, and we will issue our decision in due course. We are going to stand at recess. I certainly wish you all the best. Please stay safe and healthy out there.
Thank you so much.
Thank you.